Okay, well, let's get started. Thank you all for joining us today for our webinar on getting paid on government contracts. We're going to be talking about fresh strategies on requests for equitable adjustments and claims. Today's webinar is being presented by Olds, Morrison, Rinker, and Baker. We are known not only for our construction law experience, but also for our extensive government contracts practice, which is nationally recognized as one of the top government contract law firms in the US by Legal 500. We work with government contractors, large and small, across a wide variety of industries, including construction, base operations, maintenance, defense, maritime, engineering, healthcare, aerospace, information technology, energy, and communications. So before I introduce our two speakers, I would like to cover a few housekeeping topics. We are recording today's webinar. We'll be posting the recording on our website, olds.com, after the event is complete. Additionally, we will be emailing you the slides after the event. So we welcome you to revisit the content yourself and share it with colleagues. We also invite your comments and questions. So please look at the Q&A box at the bottom of your screen. If you think of a question for the speakers at any point, just type it in there. I will hold questions for discussion at the end of the presentation. And last but not least, we will be hosting another webinar on April 28th on how to win your bid protest. So please look out for that invitation coming out in the next week or so. All right, so today's presenters are Howard Roth and Megan Doris. Howard Roth is the chair of Olds Morrison's Government Contract Practice Group. Howard has 3 decades of experience handling federal procurement matters. Companies particularly seek out Howard's counsel on navigating complex Contract Dispute Act claims and appeals, and with issues unique to maritime and aerospace contractors. Howard also served as a commissioner at the ASBCA and deputy general counsel at the Army Support Command in California. Howard served as the lieutenant colonel in the Army Judge Advocate General's Corps and was a trial team chief at the Army Contract Appeals Division, litigating GAO bid protest and contract appeals. It gets easier the more times you read that. Megan Doris provides her clients, which are some of the nation's and region's leading general contractors and subcontractors. Megan also helps organizations understand and secure government contracts in the construction and service industries, including a focus on Ability One providers. From assisting with bid protests and helping clients to navigate the REA and claim process, to litigating bid and size protests before the Court of Federal Claims, GAO, SBA, and state and local agencies, Megan is skilled at handling all types of government contract law issues. So at this time, I'm going to hand the floor over to Howard and Megan, and we'll begin the presentation. So.
Well, welcome everybody. Thanks for spending your lunch hour if you're on the West Coast or later in the afternoon on the East Coast. You know, we work really hard, I know, out there as companies to get government contracts. You know, protests are filed sometimes. And then we get the contract and we're extremely happy. And then as you get into, you know, actually doing the work, issues come up. There are modifications, changes, differing site conditions, and then you need to get paid. And so really what we're going to be doing today is fresh strategies, but really it's going back to basic basketball. You know, keep your hands up on defense and box out, you know, to get the rebound. I was talking to some contractors, you know, that have recently been suspended on the border wall. The president issued an executive order, and you know, you get this suspension. You're looking, well, gee, I mean, I'm going to get paid my costs, right? Well, you know, you're still going to have to submit a request for equitable adjustment. Those contracts may get terminated for convenience. In fact, I would probably bet that they would. And a termination for convenience is not is not an REA. It's not a request for equitable adjustment, and it's not a claim. Now, it can be a claim. These are just the basic facts you got to sort of deal with. And, there are sort of, I won't call them secret, but things that people don't think about to resolve your REA or your claim. I mean, did you know that you can get a mediator at no cost to you to fly out pre-COVID, everything paid for by the government to resolve your dispute if the government is willing to, to spend that day? Or if the government has no money, they don't have any money on the contract and the agency doesn't have any money, there is a way to basically manufacture money. And the basic point is to get you paid. And we'll talk about that, and but we'll start with the basics of what's the difference between an equitable adjustment and a claim. And I'm going to hand you over to Megan right now.
Okay, well, as some of you may notice, that I am not Mike Schmidt, who was indicated in our flyer, but I agreed to step in yesterday at the last minute and help out with this. I had just finished judging a 3-hour moot court competition for students who had 4 months to prepare. It was a bit of I can't imagine having 4 months to prepare for anything, but this one I'm working on about 12 hours. But luckily, both Howard and I could probably talk about CDA claims and REAs in our sleep. So, and I know that we promised you fresh strategies and pitfalls to avoid, but like Howard said, going back to basics is important because we have a lot of clients who throw around the term claim with a capital C, throw around the term REA, but what exactly is a claim and what is an REA differs internally at a lot of clients. So we thought it would be important to sort of just go over the basics. So essentially, what are the differences between a claim and an REA? And your screen tells you that the key differences: timing. An REA, there is no timeline, there's no requirement for the government to issue a response to. You can send an REA and the government can ignore it indefinitely. A CDA claim has a specific time frame, and we'll get into that a little bit later. Certifications, both a CDA claim over $100,000 always requires a certification. An REA for a DoD contract requires a different certification. The CDA claim requires a certainty with regard to the sum that you are seeking. REAs don't necessarily require that, although from a strategy perspective, Howard and I would certainly recommend that the more precise and more accurate you are with the dollars that you're seeking, the better off you are. The adversarial nature of them, that's a term that the courts have used. Quite frankly, I've never met a contracting officer who sees an REA as a true camaraderie experience. Both are viewed as demands on the government, but the adversarial nature of a claim with a capital C versus an REA determines whether or not you get attorneys and consultant fees. And that is because the courts, and we'll go into this also later, but the courts have decided that an REA is truly furtherance of contract administration, and that therefore attorneys' fees and consultant fees are recoverable because a claim is adversarial and implies litigation eventually. There are no attorney's fees and consultant fees, but you do get interest from the date on which you submit. So what is a claim, right? A claim originates from the Contract Disputes Act of 1978, or call it the CDA. Sometimes they're often referred to as CDA claims. Interestingly enough, the CDA never actually defines a claim, but FAR 2.101 does. And per the FAR, a claim is a written demand or a written assertion by one of the contracting parties seeking, as a matter of right, the payment of money in a sum certain, the adjustment or interpretation of contract terms, or other relief. Where do we see this most often, right? You're seeking money. But while a claim is clearly defined, oddly enough, an REA is not. And everyone here, there's 60 participants, has probably submitted an REA, but what does that really mean? The term equitable adjustment appears either explicitly or implicitly in several places in the FAR and in certain contract clauses, but neither the FAR nor the contract clauses define equitable. So we're left with a a subjective definition of what is equitable. And Howard will touch on REAs later and give you some strategies to make sure that your REA is as as comprehensive as possible to put you in the best position to reach a settlement with the government and or turn that REA into a claim if need be. In general, when we talk about what governs a claim or a request for equitable adjustment, we know what the FAR says, but what the FAR means and what those contract clauses mean, we're left to the interpretation of the Court of Federal Claims and the various boards of contract appeals. And they generally say that it has to be fair and reasonable. And I'm sure most of you know, contracting officers and contractors have a very different perception of what is both fair and or reasonable. And there's no hard and fast rule that will always make sure that you're all on the same page. And we'll go into some of the new cases from 2019, 2020, and even some cases from 2021, trying to wrestle with these issues. You can go to the next slide, Annette. At the highest level, why do you want a claim, or why do you want an REA? Most of the time, we are talking about money, right? That's what contractors want. They want time or they want money. And normally, if they want time, they want money associated with that time. And what does that look like, right? It's damages for a breach of contract or costs associated with changes to the contract. There's also non-monetary claims that get overlooked, I'd say more often than not. And those you're seeking time with no money. Where do we see that right now? COVID-19, right? The government has a force majeure clauses, right? Pandemics in there, and they're happy to give time, but they are not happy to give money associated with that time. And other times we see them as you're asking for what in the legal world we'd call a declaratory interpretation, right? You want someone to tell you definitively what the specs mean. The contracting officer says, or maybe the contracting officer's representative says the spec means A, you think the spec means B, you write a claim to try to get a definitive interpretation of what the spec really means. And if you disagree, you then have rights to appeal that. And we'll go into that a little bit later as well. You can go to the next slide, Annette. So when we talk about reasons to file an REA or a claim, there are, these are sort of a very broad overview, but I'd say these are the most consistent issues that arise day in and day out for both Howard and I, right? The contracting officer wants to add work or they want to delete work. Changed work, I'd say, is probably the #1 issue that I handle, and whether that's something arising under the changes clause or the differing sites conditions clause. Those are probably the most 2 prominent ones that come up. Substituting work, government's delayed work, right? They were supposed to provide certain equipment or certain materials or permits or whatever the case may be. I'd say in the Army Corps of Engineer contracts, 99.9% of the time, the issues that arise are with respect to the government having to provide certain permits. Those permits aren't provided, and that impacts the contractor's work, whether it pushes you out of a fish ladder or pushes you out of a fish window or pushes your heavy civil work into the rainy season. Those impacts can then mount. Acceleration of work is a common one. And then, as Howard mentioned, terminations for convenience, which are kind of their own entity, right? They're neither a claim nor an REA, but they have flavors of both. But essentially, we're talking about there's some modification to the contract effort. And where I see the problems for these most of the time is not where it's an overt modification. I think the overt modifications, those more often than not can get easily resolved in a change order. There may be some debate about the quantum tied to that change order, but the actual entitlement is pretty easy. Where the difficulties arise are things that you might not have realized were necessarily a modification at the time. There's a question as to whether it is, but maybe you do something once, and then the contracting officer's representatives asks you to do it again and again and again, and it's kind of the death by 1,000 cuts. You end up, for example, you were contracted to do a certain type of work. They ask you to help out with your piece of equipment over on another part of the job. You help out because you have the crane, for example, and you're going to go help them over there. They keep asking you to do things like that, and all of a sudden you become sort of their service contractor. And that's not what you contracted for. Both the time, man hours, and equipment add up. And you realize that a little late. If it is something that you realize up front, it's an overt change, you've caught it early, what can you do to facilitate either your REA or your claim? And these are basics that people who've been in the industry would remember, but I always remind people that you've got to tell your project team that's out there to set up a job cost code, track associated costs with that change. It makes approving your claim or REA that much easier. It also makes it a more convincing case to your contracting officer. Write whatever notice letters you need to write, put them on notice of the change in your contract. Direct your project staff to keep daily detailed reports related to the issue or the impact. When you get to the point where you realize, shoot, we're out a few $1 million and now we've got to go hire Olds Morrison to help us with this claim or this REA, we have to build that up from the source documents and daily reports that don't note the problem and simply say, whether 73 and Sunny moved X to Y, did A, B, and C, don't help us provide a convincing case to the contracting officer. So anything that your team can do at the source document project level helps us provide a more detailed REA, a more detailed substantiated claim, and makes the opportunity for settlement that much easier. Also mitigate the impacts to the extent that you can. Contractors often forget this, right? You have a duty to mitigate, but also track your costs and time associated with the mitigation efforts. To the extent possible, track those costs and time separate from the costs that you're tracking simply to the change itself. I'm asking the impossible sometimes, but to the extent that is possible, we also recommend that. And the other one, the big one that comes up all the time is don't sign those end of the year mobs that the contracting officer throws to you on December 28th, asking you to deobligate your funds for the year and sign away all the remaining funds on the contract. If you have REAs or claims that are either currently drafted and before the contracting officer, or you're contemplating, take a note and make an exception to those deobligations of funds as it relates to claims or REAs. Okay, and you can go to the next slide. All right, so I think generally people think about the REA first, but I'm going to start with the more formal of the two. I'm going to start with the claim, and the notion of the claim, right? The origin of it is to encourage settlement. And so they want all claims to be presented to the contracting officer. I've been doing this for 17 years. Generally, my work is 50-50 between what I would say is pure construction and government contracts. That tends to sway with the economy right now. I'd say it's closer to 60-40, if not 70-30 government contracts right now. And often I'd say a lot of companies handle claims and REAs internally. Sometimes we don't get involved until things have gone awry, but while the notion may be to encourage settlement with the contracting officer, I don't see many contracting officers take a claim and think, haha, you know what? That contractor's right, and I'm going to agree with them and give them all the money. I understand that that's the principle behind it, but I think when you draft a claim, when you prepare a claim, you've got to do so with the intention of this is going to be exhibit 1 in my appeal. So you want to be thoughtful with what you put in there. But the basic elements are that it's got to be in writing. So discussions with the contracting officer are not sufficient. You have to, and it has to be to the contracting officer, not to the COR, not to anyone else, not to, even if there's the letter that says, the COR can handle all of the things the contracting officer handles, their claim still has to go to the contracting officer. It's got to state a sum certain if you are seeking monetary damages. or has to clearly identify the relief you are seeking. Of over $100,000, it's got to contain a certification, and it has to request a final decision. And so, is there a particular magic format? No, there is no prescribed format, but it has to satisfy these elements and contain sufficient information to show the basis for the contractor's entitlement. So this year, Kiewit had a case that they appealed to the Federal Circuit, and the Federal Circuit held that a certified claim for a constructive change was valid where the claim referred back to the prior REA. So it incorporated the REA by reference and basically said that was where all the details were. And the court found that a CDA claim does not need to be issued in any particular form or any particular wording, so long as the contracting officer clearly had adequate notice of the basis and the amount of the claim and issued a final decision. And in this case, the Kiewit's contracting officer issued a final decision and then tried to argue later that it wasn't a valid claim. And the Federal Circuit shot them down on that argument. Okay, you can go to the next slide, Annette. I think what many contractors are not aware is the fact that the government can assert a claim. The government can technically bring a claim, and it does not require a certification. They can bring a claim for LDs, default termination, and one that comes up more often than people would realize is that once the DCAA conducts its audit, and for those of you, the Defense Contracting Audit Agency conducts its audit and determines that there are quote unquote unallowed costs, and Howard will cover with you later what the allowed costs are. But once they determine that there are unallowed costs, the contracting officer can issue a final decision demanding repayment of those unallowed costs. And then they have to go file a claim to seek those costs in return. So this year, there was a case before the Armed Services Board of Contract Appeals called SRA International. There, the government had two claims. They filed the claims with the board. Those claims simply referred in reference, didn't state anything specific back to their final decision letters, which is something you are allowed to do in a board case. You do not have to draft a complaint from scratch. You can refer back. I always recommend drafting a complaint from scratch, but and the board held that well, actually, so they referred back to those letters that demanded us some return from the unallowable costs. The contractor argued that the government agency had an obligation to provide more information than this sort of basic final decision letter telling them that costs were unallowed. And the board disagreed. The board said that a contractor's desire for more information is insufficient to strip them of their jurisdiction. So essentially, the government has a lower, essentially in practical application, has a lower burden of proof. I don't think that's necessarily what they intended with that, but that's the practical application. Okay, you can go to the next slide. So we've talked about what can be a claim, who can assert a claim, what cannot be a claim. Prevailing wage disputes under the Davis-Bacon Act cannot be the subject of a CDA claim. Tort claims that do not arise under or relate to the contract, because in its very title, a claim stems from the Contract Disputes Act, and a tort claim is not related to a contract. And obviously nothing pre-award. The CDA only governs post-award claims. So anything you have that arises pre-award falls into the world of bid protests, which you can learn about on April 28th. Okay, you can go to the next slide. Okay, so what is a sum certain? A certified claim requires a sum certain. This is a topic of frequent litigation. Several significant decisions come down every year as to what is or isn't a sum certain. In general, if you guys are familiar with the what I'd call sort of traditional civil litigation, people often file complaints in court that says something like, we seek damages in excess of $150,000, or we seek damages in the amount of $1.4 million, or an amount to be proven at trial. Sometimes you see something like a damages not to exceed a $2.8 million. That would be a ceiling amount. None of those are acceptable in a certified claim. They have to be it has to be a specific dollar amount. So this year there was this case called the Appeal of High Tech Laundrette. In their claim, they stated that they were seeking approximately $150,000. And then in their appeal to the board, they claimed that they were seeking an quote unquote estimated damages estimated to be in excess of $150,000. They also stated that they were requesting breach damages, and breach damages refers to that breach of the covenant of good faith and fair dealing. They were requesting breach damages of a minimum of $150,000 in lost revenue. The board shot down each and every one of those qualifications as not being a sum certain. And note that High Tech Laundrette also sought a cease and desist order against the government, which is essentially injunctive relief. And the board reiterated that it does not possess jurisdiction to issue a cease and desist. There was also another case this year in December, or I guess last year now, in December of 2019, in the Ford Lumber and Building case, where having absolutely nothing to do with the facts of that case, the board inserted a reminder that a ceiling to a ceiling amount, a not to exceed amount, was not a sum certain. Getting to your sum certain is something that is easier said than done. There's so many things that go into the amount that you want to claim, and you want to make sure when you're putting together your claim and you're arriving at that sum that you've considered all the options. So certain things that you want to make sure you want to capture all of your delay costs, and you want to capture them consistently. You want to pick a method or methodology to capture those costs. You want to make sure that you're capturing home office overhead, field office overhead, disruption and inefficiency. Again, pick a consistent methodology. What happens sometimes is contractors go and they look at a measured mile in one case, and then they look at a total cost method in another case, and they come up with two different sets of damages and sort of present both options to the contracting officer. And that puts you in that dangerous area of not being a sum certain. Okay, you can go to the next slide. Okay. And now we get to Howard, who's going to talk to you about when you are putting together your sum certain and your costs, what's an allowable cost.
Well, thank you, Megan. And before I jump into that, this exciting topic of allowable costs, I think you may ask yourself, I'm older, the talking heads, you may ask yourself, what am I doing? How can it be this difficult to submit a claim? I mean, everything that Megan was going through, you'd think, well, gee, everyone, we all know I submitted a claim. I asked for $10 million and additional days. But when I was a commissioner at the Armed Services Board of Contract Appeals, where many contractors go, they can also go to the Court of Federal Claims, or even to U.S. District Court if it's a maritime contract. But the board looks at the claim. And the first thing that I would do in my job as a commissioner is look and see, okay, was a claim submitted? And we had a form letter where we would look at it and we would raise all the reasons why it wasn't a claim. And we did that at the get-go because the government can raise the fact that it's not a claim at any time. And they love to raise it on the day of the hearing. Judge, there's no claim here. And the judge, if there is no, he doesn't say, well, gee, this is hyper technical. And so it's a very, very big deal. It's not self-evident, what is a sum certain? was this claim that you're now, you start out and you have your complaint based on your claim, and then all of a sudden you start talking about different issues. And before the trial or even after the trial, the government will say, well, these claims were never raised. So staying to the basic basketball of like the four things that Megan was talking about, it seems so obvious, but it comes back to bite even the biggest contractors, General Dynamics, the Newport News Shipbuilding. So I guess what I'm saying is, look at those slides of those 4 or 5 things that you got to do, and make sure that you're doing them. As far as allowable costs, what we want is for the government to show us the money. We want it to rain money. So I have this RAIN, make it rain. The costs have to be reasonable. Well, that, again, it's everything always has to be reasonable, but you tie it to the nature, the type of cost, the amount, and then what you did to mitigate your damages. I mean, yeah, you may be down on the border wall and you may get a suspension, right? But that doesn't mean you get paid everything. What are you going to mitigate? So how far down are you going to ramp your operations? And again, it's not an obvious thing. So when you're incurring these costs, it's always a good idea to keep talking to your higher tier or the prime to the government as to what they're expecting as far as mitigation, so that they don't come back later and say, well, these aren't reasonable. You could have done X, Y, and Z to, and we use that, legal term, mitigate, basically to decrease your costs. So in addition to being reasonable, they also have to be allocable, and you got to be able to allocate it. And so what can you allocate? Your direct costs, that's clear, the people that you're paying, overhead, general and administrative costs. All of these, though, have to be in accordance with the cost accounting standards or your generally accepted accounting principles. Whenever I hear like cost accounting standards, my eyes would, start to glaze over. And, the whole reason that I became a lawyer, most of these judges that, it's very disappointing to contractors because they go before a judge who, he majored in history because he can't do math and he can't follow bar graphs, but yet you've got to educate them. And so what I've learned is the cost accounting standards really aren't that difficult. And in many ways, it's close to the generally accepted accounting principles. In other words, how you are allocating and always have allocated your costs when you're doing business. If you're following the standard rules, you should be okay. But you can't be in conflict with the contract. If the contract says that you can't claim a cost, or the cost principles say you can't, well, then it's not going to be reasonable or allocable. Next slide. So we get into what is reasonable. Well, it's subject to interpretation. And when things are subject to interpretation, what I always say is, well, come up with 8 lines, your elevator speech as to why it's reasonable. A cost is reasonable if in its nature and amount, it does not exceed that which would be incurred by a prudent person in the conduct of competitive business. Well, what does that mean? Well, if you're putting together an REA, the rules say that you can get the fees of your attorney to give you advice, and you can get the fees of a consultant to help you, make sure that you're adhering to those cost principles. And what you would do is you would get an estimate from those folks. Tell me, Howard, how much is this going to cost me? And the consultant would also do that. And the court is going to look, okay, you paid $100,000 to to your attorney to draft up this REA and give you advice. What would other businesses have paid to do that? So you sort of have to do your market research to make sure that, this is what a normal person at arm's length would reasonably incur. So you'd have your 8 lines. Well, Howard's hourly rate is, is much less than what the Department of Justice says is average. It's interesting right now, the Department of Justice, when they're paying legal fees in court cases, like at the Court of Federal Claims or in U.S. District Court in Washington, D.C., they say, well, for a lawyer with over 25 years experience, if you prove to us, the government, that you incurred an hour, then the going rate is $785 an hour. So I'm well below that. So clearly I'm a reasonable, and you can point to that. And I often do that in my REAs, there's my hourly rate. And then I have the Justice Department's own memo saying that I'm well under that. And that, what the contracting officer can't say much to that. And it's your burden to show that you're reasonable. And so, that's a way to show that your lawyer is reasonable. I mean, his hourly rate is less than what the government considers to be an hourly rate that they would pay for someone's time. Next slide. Profit and interest. Well, as far as what's a reasonable and customary profit for a claim or for an REA, and again, an REA is not a claim, and we've talked about the fact that many times you want to start with an REA because those legal fees and consultant costs can be reimbursed by the government, whereas legal fees to put together a claim cannot be reimbursed by the government. So that that's an important consideration. But what is a reasonable and customary profit? Well, the government has these weighted averages or guidelines that are in the DFARS. The court is not bound by them, but many times they're going to look to them. And if you want to claim a higher, why would you claim a higher profit? Well, if you're in the environmental remediation, and I was dealing with remediation of a vessel that had been powered by a nuclear reactor, certainly the profit in that business is got to be higher. And it has to be higher. It's interesting when your employees, you want to keep them because with nuclear, they might start to glow. So what they do is they had safe units where the government, because it wasn't safe, and they didn't want to say to their employees of the contractor, well, gee, this isn't safe, you could glow. So they paid additional profits so that the contractor could pay increased safe units for sticking around the contract from beginning to end as they got more and more radiation. They were dedicated employees, but they like to get that additional safe unit for being in an unsafe area. Again, nuclear remediation, you're going to be able to show that the guidelines don't apply to us because it's dangerous, or this required a lot more detailed work than you would normally do a contractor would do on a construction project, for instance, under the weighted guidelines. Now, don't forget that G&A is not to be excluded from your profit calculation. Interest. With the Contract Disputes Act claim, you can get interest from the moment that you that you submit your claim to the contracting officer. And again, it's going to be a claim for a sum certain. I want $100 million as a matter of right. I am due this money, and And, you know, it's certified because it's over 100,000. Here's my certification. And, you know, again, affirmatively state that you want a contracting officer's decision. And then if you've got that claim, if it meets all those elements that Megan talked about, then interest will start. You know, of course, the government may argue, you know, years into litigation that it wasn't a claim. And that's why we're here to make sure that you are going to submit a claim. And then they're going to argue that no interest is running. And then, you know, the question often comes up, what about my financing costs? And those are not an allowable cost. So unfortunately, you can't get that type of interest. Next slide, please. And now we go to one of my favorite things, and I think Megan is going to talk about this, but certifications.
Okay, there was also a question on this issue within the Q&A chat section. What is a certification? Can you explain it to us? Certifications, so in general, what's required in your claim is set forth at 41 USC 7103. And it sets forth the requirements for what a certification has to meet. FAR 33207 actually tells you what the certification has to say. It really just condenses what's in 41 USC, but the certification has to state, I certify that the claim is made in good faith, that the supporting data are accurate and complete to the best of my knowledge and belief, that the amount requested accurately reflects the contract adjustment for which the contractor believes the government is liable, and that I am duly authorized to certify the claim on behalf of the contractor. So I can't tell you how many cases there are year in and year out on what is and is not a certification and whether that certification is defective. What I can tell you is never, ever submit a claim without the language that is included in FAR 33207. You want to be fighting with the government about the substantive merits of your case. You do not want to be spending tens of thousands of dollars fighting government motions to dismiss for improper certifications. So this year, there's a couple key issues that came up. To be clear, your attorney cannot certify a claim on your behalf. There was a case this year where the Court of Federal Claims dismissed the CDA claim in its entirety, saying it didn't have jurisdiction because the attorney and not the contractor signed the certification. The attorney may very well have been authorized to certify the claim on behalf of the contractor, as is stated in FAR 33207, but the court held that that's not what the certification meant. What that means is it's someone within your contractor entity that has the authority to certify in terms of his actual job description, his or her or their job description or title. We also had some cases this year where, you know, an REA got converted to a claim, and whether or not the REA certification, which is different, an REA certification under DFAR 252-243-7002. The language is different in that certification. Again, the courts kind of went through the complexity of what the differences are, and, you know, does that certification meet some of the requirements of a claim certification? The court ultimately held it did. But again, this is not something that you want to be spending your money on. So make sure that when you're submitting your REA, you're using the proper REA certification. If it's a claim, if it's an REA before a DoD agency, and if it's a claim under the Contract Disputes Act, that you're following FAR 33207. Okay, next slide. Okay, so what does this mean, right? I talked a little bit earlier about what a claim timeline is. There's some key time frames that are relevant when it comes to a claim. First, you have to submit your claim to the contracting officer within 6 years of when the claim arose. That means when you knew or should have known about the circumstances giving rise to the claim. So a differing site condition, the clock starts to run the day you discovered or should have discovered that differing site condition. It is not from contract award or contract to completion. So those are, again, issues that get litigated year in and year out. There was a case this year called Anna Savasta Construction Company before the Armed Services Board of Contract Appeals, where the parties they gave notice of when the claim was, and then the contractor and the contracting officer continued to negotiate payment for that work for years after. And because they were in the negotiation process, the contractor didn't submit a claim within 6 years of knew or should have known, and the court booted their claim out for not having met the statute of limitations, which seems contrary to the concept of negotiation and giving the government the opportunity to settle, but that is what the court held. So always make sure you have that in the back of your mind. And this is especially relevant on option contracts where you've got a base year or base period of term and then some option years that can be exercised. There's a lot of times where contractors are about to come up on that option period, or it's a contract that's got some negotiable issues, and they don't want to submit the claim because they're in the process of negotiating, and they don't want the contracting officer to, be resentful of them. But I have one right now where the issue arose for year after year after year. The government in its technical exhibit said it was going to provide certain pieces of equipment for the contractor to do its service work on the base. The government didn't provide that equipment, but the contractor decided to negotiate with the government for 8 years before deciding they were going to file a claim. And unfortunately, they lost that first 2 years of rental equipment eligibility because they were negotiating. So they could only claim for the latter portion of time. So those are some key things. Also, the contracting officer has 60 days to issue a final decision for claims under $100,000, or 60 days to advise you of the reasonable time when it will decide claims above $100,000. I have never, ever actually had a contracting officer decide within that 60-day time frame. They've always given a date after that. So that's just something to keep in mind. I think contractors latch on to that 60 days as the magic number. You should be aware that it says that, but it isn't that in practical application. Okay, next slide. So I just said they needed to issue a final decision. What does that mean? The final decision needs to be just that. It needs to be the contracting officer. It needs to say somewhere in that document, whether it's the RE line of the letter, it's the conclusion, it's the initial paragraph. It needs to state that this is the contracting officer's final decision. If they do not issue that final decision, they don't issue you something in response, that's what we call a deemed denial. I also have another case right now where the client submitted a certified claim and the contracting officers changed over. They've gone through, I think, 8 contracting officers on that particular project. The contracting officers changed over in that 60-day time frame, and they never issued a decision. So they've gone deemed denied for their appeal. And as I'm saying, it needs to say a final decision. It does not need to have the exact language of FAR 33-211. That issue came up this year before the Civilian Board of Contract Appeals. But the decision in that particular case did note it was a final decision. It just didn't recite the FAR language. That was not enough on the contractor's part to try to get that issue before the boards. All right, next slide. Okay, so you have either gotten your contracting officer's final decision and it was denied, or they have neglected to issue you a decision and it's deemed denied. Now what? You have 90 days to appeal to the Board of Contract Appeals. Most of you attending this, based on my review of the list, are going to end up with appeals at the Armed Services Board of Contract Appeals or the Civilian Board of Contract Appeals. The ASBCA is generally responsible for handling all decisions from contracting officers for DOD, Department of the Army, Department of the Navy, NASA, and certain CIA contracts when they're specified. The Civilian Board of Contract Appeals hears disputes from all other executive agencies except the Postal Service, the Postal Rate Commission, the Tennessee Valley Authority, and the FAA. So you have 90 days to appeal to one of those boards, or you have 1 year to appeal to the Court of Federal Claims, which is a special court in Washington, D.C. that shares a building with the Federal Circuit. And those judges hear only federal procurement, certain federal procurement decisions and vaccine cases. We could give you a whole other 2-hour presentation on why you would choose the board versus the Court of Federal Claims. But in general, I would say that the prevailing concepts are cost, time, your availability or options for ADR or alternative dispute resolution, whether you want to deal with agency counsel or DOJ. So if you appeal to the boards, your opposing counsel will be an agency attorney. So if it's an Army contract and you're appealing an Army decision, you're going to get an Army attorney. If you appeal that to the Court of Federal Claims, you're going to get a Department of Justice attorney. And that can matter depending on how far your settlement negotiations went during the claims and REA process, right? If you've developed a truly adversarial relationship with both the agency attorney and the contracting officer, the Court of Federal Claims may be your better option. I used to say that the Court of Federal Claims was faster. Board decisions right now can be 3 years before you get a final decision from the board. There are many other benefits to the board that Howard will cover later in terms of options for ADR. But right now, I'd say I also have Court of Federal Claims cases where I've filed a claim appeal in 2018 and the case is still sort of just hanging out there. So just something to keep in mind. Okay, you can do the next slide. Okay, and I'm going to turn it back to Howard now, who's going to talk to you about the less formal approach for a request for equitable adjustment.
Well, thank you, Megan. And I just to turn when Megan was talking, I thought, I have to say this to our audience because we want to give them a perspective that they're going to take away and really have learned something. Just because you get a final decision, just because the contracting officer read your claim, wrote you 30 pages as to why he's or she is denying it, it doesn't mean that 4 years later or a year and a half later that the government can't argue and file a motion to dismiss saying that you never submitted a claim in the first place. So just because you get a final decision doesn't mean that you're set. You still have to make sure that what you gave that contracting officer was a claim, because the fact that they thought it was a claim doesn't matter. All that matters is whether the court or the board thinks that a claim was submitted. The other thing is, I know we have folks out there that work on for instance, the port contracts, ship repair, dredging, working, basically anything around the water. If it's a maritime contract, if it deals with the water in any way, navigable water, then you don't have to go to the boards of contract appeals and you don't have to go to the Court of Federal Claims. You can go to a U.S. district court, and that is a nice, that's a fresh way of looking at it, because you can get a much quicker decision. Of course, you also get a judge who knows nothing about government contracts, which can be helpful sometimes because they're going to be a little bit more practical. So moving on to sort of the building block of a claim, which is a request for an equitable adjustment. It's less formal than a Contract Disputes Act claim. But what I normally tell clients is what you really want to do is make your request for equitable adjustment so formal that if the government doesn't pay you, that you can convert it, you can make it a Contract Disputes Act claim with just maybe a 1.5-page letter that makes sure that you hit, the 4 to 5 areas that Megan talked to you about, making sure it's a sum certain and making sure that it's certified properly. So it's less formal, but you do want to make sure that that you're being thorough. And your REA is going to be based on a lot. Most of them are constructive changes. I mean, even some of the other clauses like suspension of work, you want to try to say it's a constructive change because you can get profit on a constructive change, and that's not always going to be the case with a suspension of work. Termination for convenience. A termination for convenience settlement proposal, it's not an REA or a claim, but it can become a claim if the government says no to that termination for convenience settlement proposal. And the important thing with termination for convenience settlement proposals is you might have an REA in addition to the termination for convenience costs, and you have to make sure that you separate it out. But in general, you're asking to get paid for some type of impact that you've had, time or money, and you need to tie it back to the clauses and make sure that you're meeting what's required as far as the elements that you've got to show in those clauses. Next slide. So there's two things, that you're dealing with: entitlement and quantum. And again, I'm going over entitlement and quantum because it's a really huge deal, especially if you end up with a claim and you go to one of the boards of contract appeals. Because at the Board of Contract Appeals, when you get your decision, let's say you submitted a $10 million claim, you're not going to get a decision that says you get $10 million if you win. The default decision you're going to get is that you're entitled to money and to work out what the quantum is with the contracting officer. So you want to show that you've got entitlement as a constructive change, or that you've got entitlement as a suspension of work. And then you want to show in real time what those costs are that you incurred. You don't want to end up, the situation of this tent maker recently for the Army. He put together an REA. It was a great REA. It showed that, he should get paid for all these tents. And the government eventually, he converted it to a CDA claim. He went to appeal it to the board, and he went and he got his decision. And the board said, you were entitled to all of your costs. You definitely were wronged. However, you didn't have real-time evidence of the quantum of the amount of your costs. It was all after the fact testimony by your president, and so they got nothing. Entitlement and quantum, two different things. You may be owed, but you've got to show with real-time, in other words, evidence of what was happening at the time the costs were incurred. And remember that you've also got to have a certification, and that certification isn't the CDA certification. Next slide. It says, I certify that the request is made in good faith and that the supporting data are accurate and complete to the best of my knowledge and belief. Now, these certifications, you may wonder, well, gee, Howard, I mean, I've got the words from the CDA, I got the words from the DFARS, no problem, I'm going to sign. Well, hold the horses here, because what you're basically saying is that the contractor is being put on notice that you're going to have to disclose all the facts on your cost and pricing data and the actual cost information to support any estimated costs. What you don't want to do is to put together an REA again that clearly reads that, yes, they owe us money, but not have gone back like a doubting Thomas and made sure that all your cost and pricing data is accurate. Did you actually go and see the receipts that your subcontractors paid? or did you just go based on a spreadsheet they gave you that they paid the money? Because there are civil and criminal penalties that go along with these certifications if they're wrong. So, you know, the certification is needed so that it is a claim, so that it is an REA, but it, you know, you've also got to go back and make sure that you understand that you've checked all the costs and pricing, and that, you know, you can actually trace it to a cost that was incurred, or if it's an estimate, that you can back up the estimate for that. Next slide. Attorney and consultant fees. Well, you know, it's near and dear to my heart, because I always want, for my REAs, you can get my legal fees, and you can get your consultant fees, and they're presumptively allowed. So that's what's great about an REA. You know, that legal bill, you attach it as a, you attach that as an exhibit to your REA, and your REA now goes up by that very reasonable amount that you know from your market research that you've been charged by your lawyer or your consultant. And you can also, as you remember, you don't forget to add on your G&A and profit to those legal fees, because you can do that. It's just it's another cost of the change. And basically, they're going to look at the reason that you incurred those costs. So again, you know, looking back to the border wall, what a lot of, you know, with the suspension, what a lot of the prime contractors are doing in their letters to their subs is saying, hey, you know, you should go out and get legal counsel. You know, thank you for that advertisement. And you know, it's reimbursable as an allowable cost, because it's going to materially further the negotiations process, because the government's not going to pay you unless there's entitlement and unless you can show the quantum. And you know, entitlement lawyers can help a lot, and quantum, those consultants definitely help a lot. So, and if those negotiations fail, and then you've got to make it into a claim fine, and once it's a claim, you can't claim those attorney and consultant fees. But the big benefit of the REA is the cost of your attorney and consultant are allowable. You can get paid for that. Now, it doesn't mean that they're automatically going to say, yes, I'm going to pay your REA and pay all your attorney's fees and consultant fees. However, when it's eventually settled, and, you know, I really got to say this, because you know, it's hard to be a contractor, but the government loses most of the time. They do. I mean, the board just issued their statistics, and last year they resolved 250 appeals. 100 were a decision, and about, you know, another 250 were settlements, or 200 were settlements. And when the parties settle, the contractor's getting something. So for those 200 that settled, of course, you know, the government ended up paying, and hopefully, if it started out as an REA, some of your attorney and consultant costs. Then of the ones that actually went to a decision where the contractor stuck with it through the end, you know, which we're talking years, the government won 50 and the contractor won 50. So out of those 250 that were resolved through settlement and the merits, the government won 50 out of 250. But then the board also does ADR, and over 90% of the time, when the government agrees to ADR, the appeal settles. And so another, you know, 80 appeals were resolved through ADR. So that's another 80 where the contractor got something. So if you add that all up together, and of course, you know, not being a lawyer, my math isn't all that great, you'll see that out of the 330 or 340 appeals that the board resolved through ADR, settlement, and trials, that the government only won 50. Next slide. Which one to choose? I mean, in general, I think you want to start out with an REA, because you can get your attorney's fees and your consultants. It depends on your relationship. There are situations where you know they're not going to decide the REA, or you've got a bad relationship and you just want to get it to a neutral, independent party. and so you're going to go straight to a claim. You know, you want to look at, are you confident of your entitlement? I mean, if you are, then you might want to go quicker to a claim. You know, you want to look basically the history of the issue with the government. I mean, is an REA going to educate them? A lot of times the government just hasn't taken the time to really learn the facts such that they will sit down and be able to converse intelligently about why you need the more money or time. And then an REA again is the better way to go. But there have been times when I work with clients who they've submitted a claim and then they've gotten immediate action because it actually has deadlines that it requires the government then to read and understand what's going on. Next slide, please. Converting your REA into a claim. You want to, my personal feeling is you want your REA to be so complete that all you've got to do is put a letter on the top. And I don't know, Megan, did you want to speak to this slide or at all?
Sure. The other thing I always try to emphasize is, depending on when you submitted your REA, it may have been 2 years ago. If that change has continued, if it was not a one-off change, if that change has continued to impact you, to make sure that you review and update your REA. And I also want to make sure that, you may have had a legal theory, you may have done the REA by yourself, you may not have consulted an attorney. If you are now at the point where you think there may be different avenues for recovery, to make sure that you've thought about your legal theories and set them forth in your claim, because when you then have to convert your claim to an appeal, you can't add new legal theories at the appeal point if the contracting officer hasn't had the opportunity to review those theories at the claim standpoint. And there were a bunch of cases in 2020 and 2019 on that issue. Since we're running a little short on time, I won't go into a ton of detail for you. But like I said earlier, you've got to think about your claim as Exhibit 1. It's the first thing that either the board judge or the Court of Federal Claims judge is going to look at. So the more detailed it is, the more polished it is, the more backup that you can have with it. Always, always, always include the backup with your claim. I can't tell you how many times a client comes to us at the appeal stage and I got like a 2-page claim and I've got nothing to work with at the appeal stage. It's got to be thorough. All of your exhibits should be attached. Like Howard said, the more detailed you are, the better. And just don't forget, I mentioned these earlier, when you are converting from your REA to your claim, to change the certification and to make sure that there's a proper request for a final decision. There were so many cases this year litigating that very issue as to whether or not you'd ask for a final decision, or whether in what universe, I don't know, that you're submitting a demand to the government for tens of millions of dollars that you're not asking them to issue a decision on it. But again, it's just not one of those things you want to waste tens of thousands of dollars litigating. If there is an easy out, the government is going to take it, right? If they can avoid the substance of entitlement and quantum, and they can kick you out on some easy, superficial jurisdictional issue, they will latch on to that for everything they've got. Don't give them that opportunity. Make them focus on the substance, and that's 9 times out of 10 when your case is going to get settled.
Yeah, those are excellent points. Again, clients, they really want to shoot me. Shakespeare said, first thing, kill all the lawyers. So I always have a flat check it. But the first thing I want to do is see the REA and see if they actually have a CDA claim. And people have been working on these issues for years. And when I tell them that they don't have a claim and that we've got to go back and fix it, it's very frustrating. But it's not just the government attorney that can raise it. Many times the board, the judge at the board will raise it. I've had cases, large construction cases, where after the trial is done, when he's writing the decision, he says, oh, I noticed that maybe this isn't a claim. Could both parties address it. Well, luckily, you know, we showed him that it was a claim, but still, it's not something that place you want to be. Basic basketball. Next slide, please. Okay, well, I want to just do a couple of little, I call them, I think of them as tricks, but I did them a lot when I was with the government and on the other side. And that is if, you know, the government says, well, gee, Jack, you know, gee, Howard, we want to pay you, but there's no more funds on the contract. And the agent, you know, we don't have any more funds available for this year. And, you know, wouldn't you just, you know, if we had the money, we'd pay you. Well, then immediately what you should say is, hey, how about we just get it paid from the judgment fund, which they're you know, that has a constantly printing money from the judgment fund. And how do you do that? Well, you tell the government it's simple. I'll convert the REA to a claim, right? You can either write me a one-page letter denying it, or we can wait 60 days. I will appeal to the board, and then you know, the board doesn't even have to see our settlement agreement. You can just settle with me with what you think I should be paid. It's a $500,000 claim. You don't have the money. You want to pay me $350,000. We'll settle it. And then the board issues a one-sentence decision. It just says, you know, you filed your notice of appeal, which was one paragraph. It's docketed. You then do another letter that says it's settled, and then they give you a decision that says we issue this decision in the amount of a declaratory judgment in the amount of $350,000. You then can take that judgment, you go to the judgment fund at Treasury, and the Treasury pays you. Now, the theory behind all this, the theory, and this is what I loved in the government, is that at some point in time in the future that the agency will pay back the judgment fund. Well, I can tell you, they've never been able to audit the Pentagon. They've been working for years and years and years. And a lot of times it just doesn't happen. So, and since the Pentagon can't be audited, no one would ever know anyway. So a nice little way to get paid if there's no more money on the contract, and if the agency doesn't have any money, the judgment fund. Next slide, please. Okay, you know, lawyers are fixated, a lot of lawyers, on the formal process. One of the things that if you have an REA or if you have a claim, you've converted it to a claim, that people don't realize is you can go and you can send a letter to the Armed Services Board or the Civilian Board, and you can say, listen, I have submitted an REA to the Corps of Engineers, and you know, I have asked the Corps if they'd be willing to mediate, and I understand that you'll fly a judge out at no cost to me, you know, to wherever I am, you know, Spokane, Washington, Portland, Oregon, and sit down with the Corps and with us to mediate at no cost. It's what's known as an off-the-docket ADR mediation service. And they'll also do it if you've submitted a claim. Before the CO's decision, they'll sit down with you. You know, so that, you know, they don't, like Megan said, they don't really do it in 60 days anyway. And the beauty of it is you're getting somebody who 3 years later would be deciding your case anyway, to tell both sides, you know, what holds water and what doesn't. The key to all of this is the government has to agree. But, you know, the Contract Disputes Act says that they're required to tell you, if they won't agree to ADR, they're required to tell you why. And a lot of times, if you know, again, it's the way it's the way to go. This free ADR, think about how much money you may have spent for arbitrators. Remember how much those arbitrators cost? Well, gee, you could have got somebody who you're going to hire once he retires from the board to be your arbitrator, and you could have gotten it at no cost. And again, they pay his hotel room and his food.
And I'll interrupt here with one thing that I've used successfully in the past with the Navy, where I had a agency Navy attorney refuse to go to ADR. There's this magical memo on the internet from, I think, 1994. It's truly like a typewritten memo from someone's typewriter that says that the Navy believes that ADR is the right way to go. It's cost saving for the government. I put that memo before the agency attorney, and he changed his opinion and participated in the ADR with the board.
ADR, take that away. That's the fresh approach. Litigation is extremely expensive, and you have to calculate that into your, just thinking about settlement. Next and last slide. So key considerations. There are a lot of decisions we've talked about that in the names Megan mentioned, but over and over again, failure to submit your claim to the contracting officer for a final decision. You can't bring something up new during the litigation. Well, yeah, my claim's for $150,000, but there are these other costs. It all has to go together at once. Alleging bad faith against the government, in a contract termination. I mean, there's one or two cases out there in the history of government contracts, but it's not going to hold up because the government is presumed to have acted in good faith when they do their duties. And so if you're alleging this bad faith, it becomes such a high burden, you're never going to meet it. I mean, what you can do is say that they breached the duty of good faith and fair dealing, which is a much lower level than saying that they acted in bad faith. Allegations that there's some third party that interfered with the contract. The government can't be held accountable for these third parties, absent, a contract term. So you're essentially wasting your time and money. Not doing your due diligence to track and record work to quantify your damages. Remember the tent case? They won. We won, but oh, I'm sorry, your president testifying that you incurred all the costs. Where are you? You didn't put into the record the cost run. No proof of damages is shown, no causation is therefore established. Another reason why it's great that the board only does entitlement, because if you win on entitlement, then you've got all the time in the world to bring all these records to the contracting officer. If you litigate quantum and you didn't put the stuff into the record, well, then you're stuck with that. And it's very upsetting, to say the least, when they say that you should have got money, but we can't order you to be paid anything because the proof's not in there. I know we've run a little bit over, but thank you. I appreciate all the time and effort that Megan put into this, coming in to assist when Mike wasn't able to.
And I will say that there were a bunch of substantive questions that were asked that I went through and answered while Howard was presenting. So there were questions about what to do for COVID-19 in terms of excusable delay and stop work, et cetera. I've referenced the applicable FAR clauses in some of those answers. There were questions about, how do you handle a termination for convenience, which Howard also answered. But if there were some substantive questions that you may have had or asked, that I've gone through and typed an answer for you.
Okay,
right, well,
I do.
Go
Yeah,
ahead.
I do see some questions. I don't know if the CO does not respond within 60 days, is the contractor then on the clock, or is it told until the CO responds to the contractor? Did we respond?
I answered all the substantive questions that were asked.
You are so good. Thank you.
I can multitask.
All right, well, thank you all for sticking with us. I know we're 5 minutes over the official stop time. So thank you for sticking around. As I mentioned, this is being recorded, and we will send out the slides and also the recording, and this will also be posted on our website. So you can come back and revisit because it was a lot of information. And lastly, I just want to remind folks that our next presentation is April 28th. It will be on a Wednesday, not a Thursday, and it will be on how to win a bid protest. So we will be sending out that registration info in the next week or so. So I want to again thank Megan and Howard for sharing their insight and expertise. And with that, I will let you go. Thank you so much for joining.
Thanks.
Thank you.